Welcome back to Inside Sources. Today I'm opening the show with a major development in the case of Sunday Jackson, who you remember in 2015 was in his farm when he was attacked by a herder who brought out a knife. It turned into a wrestling, and Sunday Jackson managed to defend himself, and in the effort, the attacker died. The matter went to court, all the way to the Supreme Court, and Sunday Jackson was returned as guilty, sentenced to die by hanging. Now, that was quite a bit of devastation to many people, including myself, who was in Newman in 2017 on the vice presidential delegation to witness some of the attacks perpetrated by the herders against the entire community. And so, the matter has been on for a while, and we have good news because there is now some bit of reconciliation with the father of the deceased agreeing and asking the governor of Adamawa State to set Mr. Sunday Jackson free. So to discuss that development and quite a few other developments around this case, I have with me Mr. Emmanuel Ogebe, a US-based Nigerian lawyer and human rights advocate, and also Dr. William Devlin, an international human rights advocate. Ogebe and Dr. Devlin, welcome to Inside Sources.
Great to be here.
All right.
Thank you. God bless you.
Good. And thank you both for the work that you are doing on this Sunday Jackson thing, bringing it to the fore and pushing this clemency plea. Let's start with Ogebe. Can you just give us an update how it is that you now have the father of the deceased to actually say that, look, it's okay to release Jackson?
Yes. Well, first of all, I want to say that yesterday when we got back from Newman, we heard that the Supreme Court has released the judgment after 2 weeks. But we've gone beyond the judgment. We're now at the clemency stage. And I am happy to report this is an amazing breakthrough. The Hama Bachama, that's the king of the Bachama kingdom, had hosted the members of both families prior to our arrival. And they mediated the issue. And the father of Jackson's attacker, a gentleman named Ado Bawuro, said not only was he not aware of the case, that, his son's, killer, so to speak, was tried, but that he doesn't support his execution. And they literally presented to us there a letter he had already signed before we arrived to the governor asking for his pardon, not even clemency, outright pardon. And so we saw the letter, we edited it because there was an error. It's a death sentence, not a life sentence. And he signed it right in front of us. And I'm happy to report that yesterday in Yola, we delivered the letter to the governor of Adamawa State. So that's in the bag.
Okay. So just before we bring in Devlin, I'm going to read a copy of the letter that I have here, signed by Ado Bawuro, who is the father of the deceased. And I'm going to read a portion that is quite instructive. He said, in this regard, Your Excellency, the letter is written to the governor of Adamawa State, Alhaji Umaru Fintiri. He said, Your Excellency should count us out of the judgment passed on the victim, Sunday Jackson. My son can never wake up again. Based on this fact, I am pleading for clemency on Sunday Jackson to be pardoned and set free. This is quite very, I like the fact of the reconciliation work that you guys have done. So, Dr. Devlin, can you tell us, how, what you have observed and what you think about this case generally?
Thank you, and God bless you and your viewers. And Sunday Jackson is an innocent man. How do I know that? Because we have met with Sunday Jackson February 19th, 2021. That's when I first heard about the case. We went from Abuja to Yola and then to the Adamawa State Prison there in Yola. And the warden allowed us to see Sunday Jackson. And we heard the story of what happened from his own lips. And then we had the opportunity to minister to him and to pray for him. And then fast forward, as you just read, there have been some incredible developments evidence in this entire case. Not only over the last 2 weeks through our over now 40 media interviews, both print and TV and radio, we have increased the awareness of this innocent man, Sunday Jackson, who was defending himself and his farm. That's what he was doing. It's clearly a case of self-defense. So when we heard that the whole case was going before the Nigerian Supreme Court on March 7, 2025, that's when we flew here from America to Abuja, and we sat after hearing 29 other cases. Finally, Sunday Jackson became the 30th case, and the case was dismissed, and Sunday Jackson is now sentenced to be hanged. And then we started this massive, not only Nigerian-wide media exposure, but it's really become worldwide. And so now we have people from over 20 countries appealing to Governor Fintiri in Adamawa State. This man, Sunday Jackson, is innocent. It was a case of self-defense. And Governor, with all due respect, you should grant clemency or commutation, time served, to this young man. And so he went in at age 20. Now he's 30. His wife, unfortunately, has moved on, but he still has two young, small daughters that we've been caring for. We also met them back in 2021. We recently received a report about their health, and so we've been supporting them financially. And that's how deeply ingrained and involved that we've been in the Sunday Jackson case. So we invite your viewers and listeners to continue to pray for this innocent young man who's already been on death row 10 years. Imagine that. And so we know that Sunday Jackson is really a reflection of many, many other cases here in Nigeria of self-defense. So we're hoping that we, as an example, even though outsiders, the prophet's without honor in his own country. So that's why we've come as outsiders, me especially, not so much Barrister Agebe, to really advocate as human rights advocates for the clemency, for the pardon, for this innocent man, Sunday Jackson.
Excellent work, Dr. Devlin, and I must commend your contribution and your passion for this case. It's quite very useful to let the world know what is going on. And like you have expressed, we do believe that Governor Fintiri will do the right thing. But let me take it to Barrister Ogebe. So in the news reports of your recent interactions in July, it was said that the Bachama, the Ama Bachama, was also involved in, because I wanted you to tell our audience how is it that you are able to get this reconciliation that produced this letter.
Yeah. Now, here's the thing. You referred to your visit to Newman after the attack in 2017. That was a horrific attack where the people of Newman were trying to defend themselves from a Fulani attack. And Nigerian Air Force planes dropped bombs on the people of Newman. I mean, it was really a horrific. I was in the country at the time, but not able to go there. And, bombs were recovered from the scene. When we tried to get a picture of Jackson after his death sentence 2 weeks ago, they told us that his home had been destroyed. Everything was gone. So no picture existed of him. Wow. So we had to send someone to the prison to take a picture of him. That's the only picture.
In the prison?
Yes. And when we showed it to his mom and dad the day before yesterday, that was the first time they were seeing their son in 10 years.
Wow.
So
in a picture.
In a picture. So this is the background. And in his letter, in the beginning of his letter, this man thanked the governor for the security that is now in place in the state, because the atrocities like that time when you visited are no longer that bad. And so what the chief did, what the king of Bachama did, which was amazing, was he tracked both families. We had been unable to track them. He tracked both families and brought them to the palace.
Wow.
And he reported to me that this is what they said
to do.
And then he called them back again for a mediation with us. And they repeated to us exactly what the king had said. And the king said to us, he said, we as rulers here are the front line of this issue. We do early warning, we do mediation, we do mitigation. So a lot of what we do, nobody knows of because it's successful in stopping conflicts. It's when we fail that you see a big issue. And, and so that's the sort of thing that they try to do, but fails. And in this situation, after the fact, the chief was able to bring everyone together and say, and the chief made a very key point. He said that we all recognize that if Sunday is put to death, it will undermine the peace efforts that we've made.
Yes.
So our security is actually in his clemency.
Yeah, actually, we really need to commend the Bachama.
Yes.
And I remember in that visit with the vice president in 2017, we also went to his palace.
Oh, wow.
A big part of that engagement was in the palace.
Yes.
We also went to the farms to see a lot of devastation.
Yes.
I am pleased and delighted, with the work of the Bachama to try and bring everybody together. Because at the end of the day, we do need the peace. I'll give you the last word, Mr. Devlin.
Yeah, and that's great leadership. And can you imagine this? I mean, we said in a press conference yesterday in Newman in Adamawa State, where else does this happen that the father of the attacker, who the attacker is now deceased, case of self-defense, where else does the father of the attacker come and ask a pardon for the young man, Sunday Jackson, who we all know is innocent? And so we just hope that he's going to soon be released. We're praying for that, and we're just advocating for this incredible human rights case that, when the world looks at Nigeria, this will actually be a net gain and an asset for Nigeria when the governor hopefully releases Sunday Jackson. And then finally, people will around the world, and Nigeria itself will be saying, this is a great day for Nigeria, that they fully understand the glory of human rights and the advocacy of human rights.
I just want to add one quick point that, the Supreme Court judgment seemed to say that, he stabbed the guy 3 times, and that was excessive. He himself was stabbed 2 times. So are we saying that the law now is that you must stab who attacks you the exact number to less drug? That makes no sense.
Yeah, the solution to Nigeria's problem is not going to come from Abuja. It's not going to come from the political class. It will come from the community. And we must commend again the Bachama and also Ado Bawuru Ari. We must commend the man, for living up to being a human being. So God will bless him.
Amen.
And we hope that this is a turning point. Thank you so much, Emmanuel Ugebe and Dr. Devlin Williams for coming to Inside Sources. All right. Inside Sources will be right back. Welcome back to Inside Sources. Now that we've had the conversation on the progress made on the clemency of Mr. Sunday Jackson, it turns out that also the ruling of the Supreme Court became available this past week, and now we know that in the 5 panel of the Supreme Court, it was a 4-1 decision. The judges that sat, the Supreme Court justices that sat on the case included Justice Ellen Morenikeji Ogunwumiju, Justice Emmanuel Akomaye, Justice Aruna Samani, Justice Abib Abiru, and Justice Baba Idris. Now, all of them except Supreme Court Justice Ellen Morenike Ogunwumiju, they made the ruling, the majority decision to say that indeed Mr. Sunday Jackson is guilty of murder and was sentenced, to Angie. Now, Justice Ellen Morenikeji Ogunwumiju dissented, but we've not been able to lay our hands on dissenting opinion. But to join me in a quick evaluation of the ruling, now that we have it in black and white, is our very good friend and Abuja lawyer, Mr. Ibrahim Wali. Ibrahim, welcome back to Inside Sources.
Thank you.
All right. So now that you've read the rulings of at least the 4 Supreme Court justices who affirmed the ruling of the High Court and the Appeal Court in this Sunday Jackson murder case, though we've not had, the dissenting opinion, it was 4-1. What's your take?
Thank you for having me. as a continuation to the previous segment. If I remember in the previous segment, I began by saying that my opinions at the time were subject to the decision of the Supreme Court being readily available for public consumption. Now, after consuming the decision, I would have to say that the decision is much more robust than that of the lower and the trial courts. Some of my fears, which I laid down previously, like the fact that the court did not look at the confessional statement against the testimony of Sunday Jackson himself, were assuaded, because the court did decide to look at it. In an appeal of this nature, the court is not confined to the judgments of the courts alone, of the lower courts and trial courts alone, but the entirety of the record of appeal, which means every single thing that happened throughout the entire case, both at the trial court, from the lowest court. So it has the privilege of looking at the transcripts of every single day and every single evidence and how it was resolved and how everything went forth before the judgment itself, which we didn't have the privilege of looking at. So it made copious references to the record of proceedings, unlike the Court of Appeal. So, for example, in regarding the viability of the confessional statement alongside the Sunday Jackson's testimony, the Supreme Court held that Sunday Jackson's testimony on stand, was an 11th hour retraction of what was in the confessional statement, and there was not enough evidence to show that that retraction was should be given more weight than the confessional statement itself. So it held that the confessional statement superseded. Yes. It also looked at the defense of provocation. Remember, I said that the court ought to have looked at all the exceptions. It looked at the defense of the provocation, and it still held that it was not sufficient enough, because the defense of provocation on one hand and self-defense on the other hand, if you don't really put them forth in an intelligent way, in an informed way, they might even clash. And that is what the court held, that but on both sides, both self-defense and self-provocation, on provocation, the court held that there was really nothing in terms of evidence by the defense before it to say that there was either provocation or self-defense. Whether I agree with that. The
judges held that there was no provocation?
The judges held that there was no provocation.
That's tricky.
Which is tricky, because to my mind, even pursuing the cows into his farm should have sufficed.
And bringing out the knife and hitting him twice with the knife.
Now, the court addressed that hitting it twice with the knife part, and it said that there was no cogent evidence by the defense counsel to actually show that if he was hit with the knife, there was no medical report, there was no testimony from, and frankly, I feel like the defense counsel, especially the trial court, could have done more in terms of bringing these defenses to life, in terms of finding actually a medical report, even if it wasn't a report, but the pharmacist who might have treated him, or the doctor, to come in and testify. And if you look at his testimony, he said that immediately after the event, he ran to his mother or his uncle or his auntie, his sister. There were 2 or 3 or 4 parties. I felt like he could have invited the parties to testify, one as to the state of his mind, and 2 as to the injuries themselves.
That's so hard.
So, but at the same time, regarding the confessional statement itself, because it was the confessional statement that the court really hammered upon as well. I feel like the court ought to have at least relied on its other decision in Najofo versus Federal Republic of Nigeria, for example, which says that if a confessional statement is not recorded virtually, either by video evidence or video recording or by audio recording, then it ought to be, set aside. It ought not to be relied upon. And I know that this is one of the grounds upon which you can, raise an objection against a document, even at the appellate stages. The law is that if you don't raise an objection against a statement at the stage of trial, then the window closes. But I know that if it is manifestly inadmissible, then that gives an exception. Yeah. So I feel like maybe the dissenting opinion would consider whether or not the admissibility of the confessional statement itself. I feel like the confessional statement ought not to have been allowed. I don't know why the defense counsel decided against the objection for the confessional statement, it ought not to have been allowed, because look, the confessional statement was taken by the police even days after the event had happened. In fact, it was transferred to them. The case was transferred to them by another police unit. So, and they had enough time to have gotten a lawyer to represent him at that stage. They have enough time to have recorded it either through video evidence, video recording or audio recording, and they didn't. So my advice to Nigerians is to ensure never to write their confessional statement without a lawyer, regardless of what is going to happen.
Okay, I wanted to, just before I release you, to talk about the state of emergency declaration by the president, including the dissolution of the democratic structures in Rivers State, the suspension of the governor and the National Assembly. Does the president have any kind of authority whatsoever to ask a governor and the whole state assembly to go and sit down?
Thank you so much for this question. This has been a very, very troubling episode for me. The president has no powers whatsoever, no matter how you want to stretch the Constitution, no matter how you want to expand Section 305, has no power whatsoever to suspend a democratically elected governor of a state and that of the House of Assembly, and to also make the declaration that to appoint a sole administrator and to give the sole administrator the power to make regulations pursuant to the agreement of was it the NEC that he said? But if you look at Section 1, subsection 2 of the Constitution, it is clear that the Federation or any part of the Federation shall not be governed in any way that is inconsistent with the Constitution. It can only be governed in a way that is provided for strictly by the Constitution. And if you look at the regime of Section 308, it does not in any way, shape, or form contemplate a situation whereby the president, upon a declaration of state of emergency, becomes some sort of a final, an alpha and omega of the entire country or the entire parts of the country. In fact, if you look at the Constitution itself in its totality and entirety, it provides for when these state of emergency powers should be activated. For example, Section 45, it talks about in a state of emergency, you can have your rights to expression, your rights to assembly reasonably curtailed. And even at that, it has to be reasonable in a democratic society, according to that section. If you look at Section 217 as well, it says that in a state of emergency, the president has the power to invite the armed forces in support of civil authorities. It is clear, in order to bring peace and order to this. So it is always going to be in support of civil authority, not to replace a civil authority. The president has no powers whatsoever, and the National Assembly equally does not have a power to upstamp an unconstitutional act. In fact, in so doing, they also usurp their own powers, because by Section 11 it says that where a state house of assembly does not have the right or does not have they cannot convene and actually make laws for a state, then the National Assembly should step in and make laws for the state. But the president's declaration was that the sole administrator would make regulations for the state, and this is basically the powers of the National Assembly in a state of emergency. But in that section, it goes on to say that the National Assembly, in exercising this power, cannot remove the governor or his deputy. So if they cannot remove him, then they cannot upstamp or they cannot affirm or ratify a decision that removes him. Right? So if you look at the totality of the sections, like Justice Walter Onogen, as it then was, in a decision, JSC, he said that you cannot read the Constitution in abstraction. You have to read it as a whole, as a community, and there is no single section of the Constitution that is superior to other sections of another section of the Constitution. But the interpretations we see so far is that Section 305 somehow gives an overarching power to the president when an SOE is called to some sort of relegate other provisions of the Constitution, provisions that have to do with the election, removal of governors, election, removal of houses of assembly. It's really abysmal. It is a decision that has really rocked my core, because I feel like it is a constitutional somersault. But frankly, this decision should be condemned thoroughly. It is not a decision decision that should stand. It is a decision that seeks to undermine our democracy, that seeks to undermine the Constitution, that seeks to, or has undermined, in fact, the rule of law, and has portended a lot of, it portends a lot of danger going forward. The decision should not be allowed to stay.
Thank you so much. And this is my view too. And now that we have your own view as a lawyer, the next segment is going to we're going to have a number of public intellectuals to look at what it is that has happened, and balance it against your legal views. Thank you so much, Mr. Ibrahim Wali,
Thank you, sir,
for coming to Inside Sources.
It's my pleasure, sir.